I love the fact that Ramon Roche is here. He is with the Dronecode Foundation, and they do open source coding. So without further ado, I'm going to hand it over to my good friend Ramon to moderate the panel.
Hello, everyone. How are you doing? Is this your first Law Tech Connect? Raise your hands. It is mine. It's nice to see everyone's first time as well. Is it your first time as well? Yeah? Good. So thank you for being here, for sticking with us throughout the day. I know that we stand between you and the end of the event, but I promise you we're going to try to make this as fun as possible. But at the end of the day, it's IP law, right? So how fun can we make this? Quick disclaimer, this is not legal advice. Please, everyone, make your research. Feel free to reach out to any of the experts up here. And let's get started with introductions real quick. I think it's best if maybe the panelists introduce themselves, and then at the end, I'm going to quickly introduce myself before we quickly jump into the first topic. So why don't we get started?
All right, well, thanks.
There we go.
Great, can you hear me? Okay, so Dave St. John-Larkin. I'm a partner with a law firm, Perkins, Coie. I work in the patent space. I'm a transactional attorney by training and with a computer science background. So most of what I touch is software and electrical inventions. I also co-chair our unmanned vehicle, uncrewed vehicle industry group. So we do, as a firm, quite a bit of work in this area, and it helps to stay on top of all the newest tech. A long time, I've been attending AUVSI, variety of different places, Dallas, other areas as well. It's been a great conference and really appreciate just a chance to learn a new lexicon, if you will. Every year it seems to change and grow even bigger. So thanks for having me.
Hey everyone, I'm Todd Basile. I'm a technology attorney at the law firm Greenberg, Traurig. Like Dave here, I do patents, but probably the other half of my practice is tech transactions, which involves any sort of deal that has a tech company or technology involved. So M&A, B2B transactions, B2C, any of those sorts of things, we help negotiate those. I co-chair our firm's robotics and autonomous technologies group. Drones fall under that very big umbrella because let's face it, drones are just flying robots. I am also a licensed Part 107 pilot, and in a former life, I was a aerodynamics and control systems engineer at Bell Helicopter.
My name's Dave Donoghue. I'm a partner at Holland & Knight, and I lead our IP practice group across the country. My practice is technology disputes with a pretty heavy focus on patents and trade secrets. I've done a number of drone-related trade secret cases, including avionics packages and some other things. And by way of background, I'm an aerospace engineer. In fact, in the depending on how you consider it, early to mid 90s, one of my summer jobs was building or trying to build a turbojet engine out of automotive parts that could be used on a drone. I'd be happy afterwards to tell you what the explosion of auto parts with jet fuel looks like, but no scars.
Thank you.
Hey guys, I'm Dan O'Toole. I'm the CEO of DroneDek, which is now called Arrive. So we use some IP because we just changed our name. I'm the only non-attorney up here, so I'm probably the nicest of any of these guys. So anyway, I'm out of Indianapolis. Love to talk to anybody that has a question about what we do. We're the next generation mailbox for all autonomous delivery. Dawn, thanks for having us up here. Thank you.
Awesome. Thank you, guys. And I'm Ramon Roche. I'm the general manager for the Dronecode Foundation. For those of you that don't know, Dronecode Foundation hosts open source, open hardware, open standards projects such as PX4, PixHawk, MapLink, Ground Control. Those are projects that are the cornerstone of the drone industry and were created more than 15 years ago. So we've been dealing with trademark issues and a lot of patent issues from adopters in our community, and I'm really excited to be here today. So before we start with the first topic, I want to mention that there's a link here for resources that Dawn collected for all of you so that you can guide us and follow through the conversations that we're having. And then quickly, why don't we jump into the first topic because we are under the clock here. What does IP mean? And I have a few questions here because, like I said, I'm no expert here. So I have a question. I'm going to put in hypothetical here. 10 years ago, and I promise this is real, I had the idea of drone delivery, drone packages 10 years ago. Do I own the IP for that? I mean, after all, I was the first one that thought about it. What do you think? Who wants to answer this?
I can start, I guess, since I've got the mic. I would say you certainly own your idea. Do you have something enforceable against other people? Probably not, unless you filed a patent application and received a patent, or unless you kept it as a trade secret, derived economic benefit from it, and somebody stole it from you, or you got a copyright on some aspect of it, and that was copied. But unless you did something to protect it and/or made some value from it, and somebody took it from you or infringed a patent, you're probably out of luck.
So does that mean that I need to implement my idea in order to make it real?
Not necessarily. You need to do something with it. You may need to patent it. You may need to copyright it. If you want to keep it as a trade secret, you have to derive independent economic value from it. So in that instance, there has to be some value in the secrecy of it.
Can I add to that? Do you care if I add to that?
Yeah, go ahead.
Yeah, thanks a lot. As an entrepreneur, the aspect that I come from is, when you have an idea, it's like an unwritten rule that 10 people have that same idea at the same time. And there's always the guy that did it, and there's the other guys that say, gosh, I had that same idea. Look at what this would have been today. And so when I had my idea for DroneDek or Arrive, I literally ran to the patent office and I filed within 4 days of having the idea, because I'd been on the wrong side of that over my career, where one time Sony had beaten me by 1 month on an idea I had, and I had another idea, and General Motors had beaten me by 3 months. And so when I had this idea, I said, man, I'm not going to get beat again. So really, execution is everything. So don't tell anybody, just run and file your IP, and hopefully you win the race.
I wish I knew that 10 years ago.
And just to add one more thought to that, this always comes up. This is my example when people ask me, hey, what's an inventor on a patent? And honestly, to get a patent on something, you have to invent something, right? So if you say, hey, look, I want a flying toaster, okay? You can't go patent that for you until you tell me how that toaster is going to fly. How are you going to build it? What are the wings? What's the propulsion? All that fun stuff. That's what has to fall into place first. So there's protecting it. There's getting it to a point where it's, articulable, and things beyond that. So just the general idea of drone delivery, not going to happen.
Okay. I have another common misconception here. So if I'm the author of an idea, of an IP, do I own the rights to it? Does the author always own the rights to the IP?
I'll kick us off. So when you have an author, authorship usually falls in this domain we call copyright. And typically what we're looking at is whether there's been something done by the author to fix that expression in a tangible media. Some way that you might capture that would be writing something, perhaps, or speaking at an event like this and capturing the audio recording of it. There are different ways of being kind of an author or having the ownership right to what you might think of as being creative expression. And the difference in copyright is that many times and often the rights attach right upon expression, right upon that moment of expression. The government does give you ways to go and register copyrights. That's a process that you can undertake. It's not really a predicate, though. You don't have to go do it first like you do in the patent and in the trademark context. So this often comes up for companies right when you first kick off. You're producing materials. You might be producing product literature, a slide deck for investors, and likely you're also drafting and writing code. And source code is one of the primary ways that companies look to protect their early and critically important IP.
Anyone else? No? All right, one more question. Do I own the patents to my IP? Are they assigned to me automatically? Is a patent assigned to me if I have an IP?
So generally in the United States, a patent is filed for in the name of the inventor or inventors, and then would often be assigned to the company if there are agreements that require that assignment, or if there's some sort of contractual relationship. But that is a real issue. It's if you're a company, it's pretty important that in your employment agreements or independent contractor agreements, you make clear that your employees and independent contractors have a duty and obligation to assign rights and to tell you about all inventions and to assign rights in those inventions to you, and then to give reasonable assistance in prosecuting any patents or other IP that you may have.
Awesome. Thank you. Anyone else? No? All right. So we got that IP I got four key points here for what IP means. We got patent, copyright, trademark, and trade secrets. Can someone talk about trade secrets?
All right. I can do trade secrets. So a trade secret is an idea that you have kept secret, that you've taken reasonable measures to keep secret, and in fact have kept secret, or until somebody took it from you, and that you derive economic value from the secrecy of. So it doesn't have to be a new idea, you don't have to be the only person that thought of it or even the first person that thought of it, but it has to be yours. You have to take reasonable efforts to maintain its secrecy, and you have to derive economic value from its secrecy. The most common example of a trade secret is the formula for Coca-Cola. Nobody knows what it is. Lots of people have tried to replicate it. There are similar products on the market, but nobody has that Coca-Cola recipe. In the drone space, I've seen, I think I mentioned, litigation on avionics packages. There can be trade secret in that. You have to have protected your software and perhaps the physical embodiment of the avionics system on your drone. I've seen fights over McDonald's and Burger King French fry batter that were quite vicious in the trade secret space, because apparently that's a big differentiator in which fast food restaurants should go to. But that's generally it. It's got to be something you created, and you maintain its secrecy and you get value from it. And then somebody has to have taken it. So it's not like a patent where it's enough that somebody does something that infringes upon the bounds of your patent, but they actually have to have taken it from you or gotten it from you improperly.
Thank you. I have one last question. And before I do ask that, is there anyone out here from the panelists that want to talk more about what IP means? What does IP mean? No? Okay, so I'm going to ask my question here. Since 10 years ago, I wasn't able to register the drone delivery idea. Now I have a great idea. I want to do try a taco delivery drone. Do I need to register that? And how expensive is that? And will I own the IP forever? Is there a limit to that?
Non-lawyer here. First thing I would do, go in with your budget question. It's very inexpensive to file a provisional patent, and it gives you 1 year protection just to get your idea out there and secure it. And then you can be iterating over that year period and still file for it. And that's a quick way that kind of levels the playing field for small businesses out there. So I think that's a good place to start.
Yeah, I'll just say a couple quick things on it. So I think right from the outset, emerging companies have kind of critical needs, right, as they start up. And one of those needs often is in the patent space, but more important, and I think even earlier, is in the trademark and trade kind of dress area. Yeah, so trademarks are often one of the first things on the list for us as we interview new companies. Your name means everything, and getting the name wrong can really lead to a lot of problems later on. And it's best to just try and avoid that. It's easier to do up front, frankly, than try to reorient and rebrand later. So usually the first checkbox is on trade dress, trade names. Trade dress meaning more of your look and feel, the style of your company sometimes can be important. But in terms of a provisional application, I just wanted to clarify one thing. It doesn't give you a year of protection. It just gives you a filing date for a year. You still would need to have the what later we would call a non-provisional patent filed and basically assessed by the patent office to determine if you qualify for a patent. It can be an expensive process, and I guess in terms of thinking about patent rights, you should think about them early, but there may be some staggering of what's most important, and usually I would move trademark rights really to the top of that list.
Thank you. All right, I think we should move on to the next topic. We got IP in the modern tech world. For this, I do have some questions. Many people struggle to see IP outside the abstract definition of what intellectual property means. Can we help our audience wrap our heads around IP? What does that mean?
Sure, I guess I'll take this one. So look at the fundamental words that are part of that term, right? Property, okay? Intellectual property is property at the end of the day. Real property is dirt, personal property is your iPhone, intellectual property are these ideas and manifestations of them, right? So if you just stop and think about IP as property and in a property context, I think that helps a lot. What is property? What are property rights? Generally speaking, they're the right to exclude others from using something. And what does that get you in the tech world? Competitive advantage. So I think, if you think about it in that way and as an asset and as a competitive differentiator, that's when IP starts to kind of come out of the abstract and into the more tangible and practical.
Thank you. And when, let's say, my taco delivery company is seeking for valuation, what should I need to care for? What do I need to know to protect my taco delivery IP?
Sure. So I heard valuation in there.
Valuation.
And I think I'll just continue with the thought. I think that's extremely important also to view IP through that lens. Because look, maybe you'll get sued for trespassing on someone else's IP, okay? But as an early stage company, you've got bigger fish to fry a lot of the time. And that's really not on your list of, your priority list of concerns, right? But what maybe should be is the context of IP in terms of taking an investment or having an exit eventually. Because every time you go to do that, an investor is going to pay one of us to look under the hood, right, and see what you have. And investors love IP. They love barriers to entry. You watch Shark Tank, Cuban's not a fan of patents, but there's often a question, hey, do you have a patent on this or whatever? And for a lot of early stage companies, aside from maybe a prototype, IP might be the only asset you have and the only thing they can base that valuation on, especially if you don't have sales or anything of that nature. So it's critically important in the shorter term for practical things like that, not just staying out of fights or picking fights with people.
So what sort of strategy would you recommend for new founders when dealing with IP?
I'll start. One of the other things I was going to add is that many of the companies you see that are early stage here at Exponential, many of you actually have both a commercial side of commercial interest as well as perhaps even a government interest. There might be a government market for your product. And so government rights are things to be aware of early on. It's pretty rare that the government's really wanting to capture commercial rights, but it is something to think about in terms of how you structure your early stage agreements, that you preserve a market for yourself later on if you do want to shift from being solely supplying government related goods and services to something that might be more commercial. That can impact your IP, and it's early to get right, or it's best to get it right early on as well.
That's a really good point. I've seen a lot of companies that have gotten stuck because they were so excited about a government contract and they kind of operated quickly on their own and ended up creating a contract that siphoned off a lot of their market before they even realized it. And as they matured and they realized they could take this idea and change it a little bit and market it across other government entities, that really wasn't an option for them, at least not as a revenue driver. They'd be more than welcome to do that, and the government might really appreciate it, but the government wasn't going to be paying extra or wasn't going to be paying more than that original contract price. So that's really critical. The other thing I think you need to think about, and you heard the point from Dave, trademark is a good place to start. One of the things that a patent application shows is credibility as an early stage company, that you're thinking about things, that you're doing it right, that you're spending the resource to protect yourself, which protects the investor down the road. You may or may not want to do that with a patent application. It could be that a provisional application gives you some time to show that credibility. I have a client who says, Dave, stop talking to me about patents. They're playing cards to me. I need a certain number of playing cards to show investors or to show a potential acquirer that I'm serious. And that's all that matter to me. And in some cases, that's true. You need to balance that, because if you need to actually use your playing card, you need there to be substance there. But doing things like having an IP plan that's written down and thoughtful, even if you're not getting a patent right away, getting a trademark or two registered or in process sends a message to those investors that you're serious and credible and doing the sort of blocking and tackling that they want to see.
Awesome, thank you. And I want to ground the conversation a little bit more on drones and robotics side. After all, data is the most valuable IP in the drones robotics space, and aside from delivery, is the number one reason that we fly, to capture data. And data has a ton of uses, therefore I think it has a lot of value. Is that data property, and who owns that?
So Ramon, I would agree that probably data is one of, if not the most valuable IP in the drone space and the robotic space. It's why we fly outside of maybe drone deliveries, right? You're flying some sort of payload that's going to capture information, whether it's imagery, whether it's other sensor data, anything of that nature. It's why we fly, right? And so at the end of the day, that's what the client is paying for. And that data, it has a purpose for the end user. It has a purpose for the drone manufacturer. It has a purpose for the service provider. And all things of that nature. So it's a valuable asset to a lot of different people for a lot of different reasons, and lots of different types of data across that spectrum. And so, I think when I think of data and I think of it as being valuable, I think of, hey, history of mankind. What happens when something is valuable, right? People fight over it. And so I think it makes a lot of sense to think of data as an IP asset, figure out who's going to own it, who can do what with what, and sort of hash that out up front so that you protect your rights and so that you don't step on other people's rights.
And quickly following up on that, if I have an inspection company and I'm get hired to run an inspection on a customer side, who owns that data that I collect? Do I own it? Can I use that? Yeah.
So I'll continue with that thought. That's going to come down to what's in the contract. In 99% of the cases, that's probably going to be the person who hired you to do the flights. You're probably, whatever data you captured, the imagery or whatever, most likely they're going to own that data under the contract. But at the same time, you need to stop and think, hey, do I want to use that data as the drone service provider, or frankly, as the drone manufacturer? For example, maybe I don't want to just be in the business of capturing data. Maybe I want to add further service offerings to my clients. Data analytics, right? So if I'm out doing inspections and I'm capturing images, wouldn't it be really cool if I could say, hey guys, we'll run that through our algorithm here. It'll pick out corrosion right there, tell you at what percentage it's at, and we can figure out predictive maintenance from there. There's a lot of value add there. It's a nice additional offering for folks. And if the other guy owns it, if your customer owns it, and you haven't reserved rights in that contract to use it for that purpose, you could be up the creek without a paddle.
Thank you. And last question on this topic, and it's on joint IP. So robotics is still considered an emerging technology, and the industry is built upon partnerships and collaboration. So what happens when we create value out of a partnership? Who owns that?
Thanks, man. Yeah, when you do that, you always try to control your own IP first, and to the extent you can control the whole situation, that's a great place to be. But a lot of times, cross-licensing might come into play where you both have IP and you have to agree to work together, or a culmination of what is developed in that partnership a lot of times emerges as being owned by both parties or all the partners. So there's all kinds of different ways to do it. I'll let the other pros up here jump in.
So I'll add a thought as a litigator. When I see a case where there's a joint ownership issue, I'm super excited. And you don't really want your lawyer to be super excited, at least your litigator. I'm excited because there's almost never a clean answer. There's almost always a misunderstanding. And when your engineer and the engineer from the other side of your joint venture get together, engineers tend to forget about the company line because they're so excited about developing and the purity of the idea and what they're advancing. I was in-house for a number of years at an auto supplier, and we had this problem all the time. When we had a joint venture dispute, we knew we were in trouble because invariably the two engineers on either side had stopped being advocates for their companies, but at some point they become advocates for the joint venture, and then you have a giant mess. So it's really important to get the contract clear. If you're doing a joint venture with IEP aspects, a lot of your IP negotiation probably ought to be an attention on how you draft that. But then you can't draft it, sign it, and then just move into the joint venture and let your contract gather dust. Because if that's what you're doing, your technical team is going to cause you problems if the joint venture ever has issues. So you really need to police that and make sure that people are behaving within the bounds and spirit of the contract.
I guess I'll just add to that too. I think that's where a lot of value comes into having an attorney with some technical acumen as well, because it's really hard to carve up rights if you can't define the different buckets of things that are going to have, be owned by who, and that folks can use in certain ways, right? So there's the typical, hey, we all own our background IP that we came into this with. Okay, maybe that works. Maybe it's not entirely clear, especially if you guys are doing a lot of the same stuff, so you might want to hash that out up front. Then there's the, hey, what are we going to create under this project together sort of thing, and who's going to own what, all of it, or what aspect of it? And then, hey, if Dave owns it, am I allowed to use it in any way? And what's it, and what way am I allowed to use it, and for how long, and all those sorts of things. So, really think of it in the context of it's worthwhile to get a prenup going into these relationships. Yeah. Protect what you had, but think into the future and protect what you're going to create together from your own perspective, but also in a way that promotes a cooperative partnership.
I'll just add real quick that there's a lot of things we're seeing in the news today about AI and its impact on various professions. Joint ownership is going to be it's going to be an area for lawyers far into the future because there's so many ways to get it wrong. So what I would say is that this is a trap. This is one of those traps where you can go and pretty easily find joint ownership agreements all over the place on the internet today. It won't take you, you won't even have to go to ChatGPT and ask for it. You can find them. There are so many different ways to think about how to divide up the world of ownership and responsibility for who does what. If you're going to file patents, well, who files? Who's got to bear the cost of it? So there's a lot of ways you can get it wrong. So I really encourage you, if you're going to spend your time and your money thinking about doing patent work, doing other types of protecting other types of IP, and you're doing it with a partner, spend the effort. The partner's going to want to do this as well because they don't want litigation down the road. So just do your homework and spend some time with it.
Thank you. And this is a nice segue into the next topic, which is protecting your IP. And I would like to get an OEM perspective. Dan, can you speak on protecting your IP?
Thank you. Yep. IP as a company owner, IP is everything. And especially when you're an emerging tech company, it's kind of the moat that you build around what you're doing, and it gives you the chance to compete with the big boys. So it's really important to protect it. Some of the things that we've done is we have what are called FTOs, freedom to operate, studies done on our IP to make sure we're still relevant and leading. And that's very important, especially when you're looking at exiting or partnering. That's a big thing. The other thing is keeping up with your maintenance, getting all the IP you can. For instance, your US patents in some cases can be rolled out to the world. under what's called PCTs. If you really think you have something relevant, you want to protect it not only in your own domain, but go out to the world. So in our case, we filed PCTs in 25 additional countries to lock up what we have here in the U.S. I told a story at the beginning how I ran to the patent office, and the end of the story is when my first patent first issued, it revealed that we had beaten Amazon by 4 days, and we beat the U.S. Postal Service by just 2 weeks, and others by less than a month. So that's a testimonial to the fact that IP is always a race. So I'll hand it off to my counterparts here.
So I'll just touch on a couple of things. So in terms of kind of the practical, what to file on and when to think about patents, there's a couple of things that I think you should do, or a couple questions maybe to ask up front. First is why, and the panel has talked about this, why are you filing? Is it offensive? Is it defensive? Is it for an investment purpose? And sometimes you have to kind of read tea leaves or kind of guess about what use you're going to have. But the reason for that is it helps you think about what's the time investment, what's the budget that you want to invest in this activity. When you file for IP, typically you need to involve your engineers in that process. And especially when you're an early stage company, that's time spent away from coding what they need to code and working on any sort of device. So I usually caution everyone, let's focus on at first at least, and most importantly, let's focus on quality over quantity. If we're going to file a provisional application, let's think about what's the critical differentiator for us. What makes us unique? And often you can look as maybe to kind of tease out the answer to that question, look at your own business deck, what you're sending out to investors. You're telling the world there's something different about us. And technically, what is it that helps us compete? What helps us be a little bit different? And that might be the focus of that first few applications, or at least that first application. And I think it gives you a good sense of as estimating, what's going to be my competition. Because you certainly do want to think about how is this going to give me some business advantage later on.
One other thought, the race to the patent office is very important, and don't tell any of my partners at my law firm that I'm saying this, but there's also an economic balance you want to make. If you get yourself with patents tend to be the most expensive. You get yourself with a patent attorney, they say, this is amazing. I see 15 inventions here. It may not be time for you to patent 15 inventions. There may be a good reason, but you really have to balance the economics and what you see your product and business life cycle being with that, because you can find yourself in debt of several $100,000 potentially to your patent counsel, and in a little bit of trouble with all these applications continuing. And in addition, if it takes a while to get to market and you start getting those patents, you've got issue fees and you've got fees in foreign countries with the PCTs, and those things can add up and be a real drain and an added stressor that takes you away from building the core of your company. So I'm by no means am I saying don't patent, but I am saying sit down, do the homework, ask yourself the hard questions, make sure you really think about it and give your best answers, not just getting caught up and getting all the protection you can.
Awesome. Great collection of tips here. Is it okay if we move on to the next topic? Does anyone have anything to say on protecting your IP? Because we're running out of time and I want to leave questions for the audience.
About that.
Yes, please go ahead.
As a layman out there, to Dave's point, if you don't have a lot of money to spend, you can go on Google Patents. It's actually a platform out there and research your idea. And it's very good at just a general search can pull up things that are very relevant. In the old days, you'd have to do a patent search, which is expensive and time consuming. Now you can do that, at your desktop and give yourself a good idea. Then you can follow up with a provisional, which is quite inexpensive. And that gives you a year to figure out where you stand. But just keep in mind that a patent is 20 years from the filing date. So the clock is ticking. You may file and wait 3 years before you know if you have a patent or not. And so what do you do in that meantime? You got to keep iterating, right? So just some things to think about.
Good. Okay, thank you. Let's move on to the next topic. Oh, actually, there's one missing here, which is liability, not tripping over others' IP. There's two high-profile IP tech fights. One is Wish versus Archer. Does anyone want to comment on that one? And the other one is Boston Dynamics versus Ghost Robotics.
I can talk about WISC, I guess. Not so much on the merits of the case. It's a trade secret and patent case between two competitors that are lawyered up very, very well. Case is about 3 years old. There are about 550 filings on the docket in that case. A filing on the docket means that a lawyer from one side or the other filed something or the court filed something. The good news for the parties is that when the court files something, you don't have to pay the court to do the work that it does. But every time your lawyer files something, you're paying. And so you're talking about a very expensive process. A lot of fights. There was, this is about drones that appeared to be similar. And to some degree, they do look similar. I will tell you, having litigated a number of trade secret cases, some in the drone space, some not, your competitors' ideas often look similar. I think as Dan pointed out, if you have the idea, 3 or 4 or a dozen people are having a similar idea at the same time. In a trade secret case, you typically don't know if the idea was stolen, unless you've got real proof that it was stolen, until you get into the discovery, which discovery is the most important or second most important. Trial can be more expensive piece of a case. So that case, they sought a preliminary injunction, which means an injunction to stop the sale of the defendant's drone. They lost that, but there was discovery, there was motion practice, there was a hearing. There's significant risk in that preliminary injunction sitting out there until it's decided. So it's a lot of risk on both sides. Ultimately, the court decided that there were enough arguments on the defense side that an injunction wasn't appropriate during the life of the case, but that case still continues. The court also, there was a motion to dismiss plaintiff's claims. The court dismissed ultimately a number of the patents, or at least patent claims, based on arguments that it was unpatentable software. Anything where you're patenting software that isn't somehow adding some new piece of hardware or that is simply codifying the way that you would do something not on the computer, that's generally speaking, although it's a very murky area of law, not going to be patentable or at least be at risk. So they lost some of their patents, which means they lose some of that moat that they've built. And it's still going on 3 years later. There have been sanctions, at least one sanction motion, maybe several sanction motions, which means you're at risk for some of the credibility of your company and or your counsel. You don't have to be worried about the credibility of your counsel so much. You can always change outside lawyers, but you do have to be worried about your credibility. And within the industry, people will see pieces of what's happening and they will largely misconstrue it because they won't understand it, but it'll all seem bad. So there's a lot of press that goes along with it, even if neither party is operating in the press. And so it's all to say it's a big process. That's a case where we don't know the answer yet. The court has construed the claim terms that the parties disputed of the patents, and the parties are at least hundreds of thousands of dollars, I would guess $1 million plus each, into litigating the case without any immediate end in sight.
Oh, did you want to say?
You know, I was just going to say a quick word on that, which is, and we have another case we're going to talk about as well, Ghost Robotics. But one takeaway you can see from these is look at the valuation that is being made and kind of in the market by these companies. You know, it's worth spending millions of dollars plus to pursue that litigation, and they haven't reached a mediation or a settlement yet. I think if there's any silver lining, it's that, wow, there certainly seems to be people that think there's quite a bit of market size, market cap in this industry.
Do we have time to cover?
Yes, we do have, I think 3-4 more minutes we can.
Okay. I'll be real quick then. So for the Boston Dynamics Ghost Robotics, I'll preface this by I don't really know much about that case other than it involves a fight over patents on the control systems, the sensing and control systems of these robots. They're the dog that you see walking around at every conference, and a lot of it is, hey, you know, how do I climb stairs? How do I get up when I fall over? How do I open a door? Things of that nature. And I only bring this up because I think there's a good lesson and a takeaway from it, regardless of the merits of the case, who's right, this or that, is you know, and this goes into your holistic IP strategy, is what do I patent and what do I keep as a trade secret, right? The general rule of thumb is if someone else can look at it and figure it out, patent it. If you think they can't, so think like computer vision, training, you know, AI to come up with algorithms, that sort of thing, you know, people aren't going to do that. But also if you think, you know, someone can't look at my stuff and figure it out, but there's a good chance they're going to come up with something similar or the same on their own, maybe you patent it then. So, I mean, I think in this case, maybe some really smart folks on both sides looked at the same problem, said, these are the sensors that folks would use in this space. This is what I have to work with the dog-like robotic architecture. Let's do this. And maybe there's overlap, maybe there's not. I don't know the merits, but I think there's just a good takeaway from that in terms of a real-world example of sort of what path to go down and why it matters.
Thank you. Anyone else want to comment on this case? Boston Dynamics versus Ghost Robotics? We're good? Okay, so quickly, let's move on to the almost last item on the agenda, which is takeaway. So the idea here is that each of the panelists is going to get 2.5 minutes for takeaways. Total, 2.5 minutes total? Oh, wow. So
right. Well, I'll go
let's run.
fast.
30 seconds then.
So well, I'll just raise one thing we've barely discussed, but it's super important in this area. Open source. Much of the innovation is moving from, or at least including now, software. It's not just about hardware innovation. And it is critical to know what aspects of your platform you need to protect and keep proprietary versus those that are going to be making use of something that might be out in the community, might be open sourced. So as a company, I would encourage you all have a view to knowing what it is that you need to keep proprietary. Maybe you protect it with a patent, maybe you protect it with a trade secret, but you really need to be aware of what it is so that you keep that captured and kind of segregated from all the other software that you're developing or using that might already be out there.
Very good point. And I'll cut down my list of 3 to 1 and keep it very simple. If you're working with other people, holla, we want prenup.
I'll address one other point we haven't talked about, and you see this in a lot of trade secret cases. You hire an employee from a competitor. It's a clean hire. You're not doing it to steal the other party's trade secrets or information or IP, but they download some stuff or they kept some stuff in the home office. Because almost everybody did something like that, not realizing. And in some cases, you may have a new employee that does it nefariously because they think that's how they're going to show advantage and get that new job. Be careful about it. Make sure you have employment agreements. Make sure you've warned them not to do those things. And make sure you're prepared if you have to have the fight about how you're going to address those issues.
Thanks. I would say IP is always a race. And if you're not first, Dawn, you're last, right? That's right. So if you have an idea, don't tell anybody about it. Tell the IP office, trademarks, patents, run, get there quick and win, because that's it. It all comes down to that. And that's why these guys are all in business here. So thanks a lot. Appreciate it.
Thank you. All right. Is question for Dawn. So takeaways and the conclusion, same thing? Or do we want to add a conclusion to the end? All right. So this is the question time, I guess. Anyone from the audience have any questions? Let's do right there. And after you end your question, I'm going to repeat the questions just for the audience out there watching this, and then I'll let you answer it.
Can you talk a little bit about Creative Commons?
Can you talk about Creative Commons?
Yeah, sure. So the Creative Commons so there's a license that is the Creative Commons license, and it can be applied to a variety of different types of works. There's actually some works that you might see that are in code. It can also be applied to things that are not code, but might also benefit from an open license. And I'm going to expand the question a little further, which is open source is not all the same. the licenses vary a lot. And so the best thing I can encourage you to do, this maybe telling you to do something you don't want to do, but read the license. Some of them are very long and some are incredibly short. Some are permissive, some are not permissive. And what's really critical is that you know how they might overlap. The overlap piece can be a little more technical, and that might be where you need the advice of counsel to help you sort that out. But the critical piece being, you may have your own development that you want to open to the world. You might say, you know what, I don't want to compete with this work I'm doing on an autopilot. I want to donate it to the community. Well, you've got lots of options. You could choose different licenses. They may give some people more or less right to use it in commercial places or to notify the world about who created it. And it may even pull in patent rights. So just be careful about what you do. Think about it. Read the license.
Thank you for that answer. Any other questions? Let's go.
Who's cleaned up a fair number of messes that contracts, for example, that were drafted without lawyers involved. I know how I answer this question. I'm interested from some of you. How do you advise an early stage company where to spend your kind of limited legal budget in terms of what's your priority from each of you on when, as an early stage tech company, when you pay money for lawyers and when you sort of hope that your decision not to get involved doesn't come back?
I'm going to try to summarize the question. So when starting a new company, when do you want to engage the lawyers?
I'll give you a 10-second answer. Corporate formation, trademarks, have an hour conversation about patents, and then based on your answers, go from there.
Right away, all the time, 24/7, bill. No, look, when you're getting into maybe some of your first agreements, especially if you're like getting into customer contracts, you're actually getting out there and pushing services, get someone involved in the beginning of that, work out a template, or at least say, hey, look, if we're working with the big dogs and they're going to make us use theirs, these are the 3 pieces we need to focus on and make sure are absolute musts that get in there. I would say getting out ahead of that one, it's certainly a lot easier to plan for the parade than clean up after it.
And both of those answers, I think, sum a lot of it up. I would also say you're going to want to check in with counsel before you're starting to have big meetings and going out to market, because that's a moment where you have to just double check and make sure you're still right, because that's when you start to have events that you can't take back and fix.
All right. Any other questions? All right. I guess we're done then. Thank you so much. Thank you for our panelists.